Legal research. This is your podcast for weeks 7 and 8. At this point in time where we head into the half point of the semester, the midpoint, midstream, whatever you want to refer it to, you should be able to summarize the elements of judicial opinions, cases. You should be able to describe the publication of cases, the elements of a typical court case. You should know the difference between the types of opinions written by judges, the majority, the concurring, the dissenting opinions. You should be able to locate cases using different research sources and organized methods, and identify the elements of analyzing and briefing cases in your own words. Let's review the elements of a case. And for some of you, you learned this in my criminal law class way before you ever took legal research. We have a case name, a docket number of the deciding court, and the name of the deciding court. We have the date of the decision. Typically, there's a case summary or synopsis that summarizes how the case got there, what the issues are, and what the court did in deciding that particular issue or issues. If it's publisher provided, i.e. Lexis or Westlaw, you have head notes. Again, head notes are publisher provided. They are not from the court. If you were to go to the official version of an Illinois case from the court's website, it does not include head notes. Those are publisher provided through Lexis, an advantage to you in researching from Lexis or Westlaw or one of those similar services. We can know the names of the lawyers, and sometimes we research what other lawyers have done as far as cases and appeals. And then you have the opinion of the court, and typically the decision, what they found, what they ruled, comes at the end. Now this is repetition, but please let it hit your ears and flow through your brain and assess whether or not it's something you do. These are some strategies for reading cases. During your first reading, focus on what or who the parties are and what the relief they wanted from the court was. Ask, what is the plaintiff's issue? What is the defendant's issue? Next, figure out what happened at the court below, and then determine what this reviewing court's decision is. Knowing the court's decision in advance will help you make sense of the case when you read it more thoroughly. And then also in this first reading, look for clues. Watch for language in the court's opinion such as, it is critical to note that, or although we have previously held that, or other signals, because what follows is often important, very important. And then as you go through in your second and third readings, and I did say third, as I told you, on my second reading, I start to highlight. Sometimes I highlight those clues that I just talked about. And on the third reading, I'm making notes. Notes to myself as how this case applies by fact, issue, or rule of law to whatever it is I'm researching. Elements of a good case brief and summary. Use complete sentences. Paraphrase. That means in your own words. Do not overquote from the opinion. I will use a quote from a court's decision on occasion, but when it's something that I want to drive home, it's typically one sentence that says exactly what it is I want the court to view the law as being. And typically that's one of those quotes that is actually repeating a long-held position in the law. And if you've taken my Administration of Justice summer course or my evidence course, some of the courses based on constitutional criminal focused law or criminal procedure focused law, you've seen many examples of that from those landmark 1960s criminal procedure and constitutional protection cases. Don't include unnecessary distracting citations, but do include correct citations from that particular case and then any other authority that you cite regarding that case. This is something that you may have heard me emphasize in other courses, and especially to the non-legal studies students. Cover the facts. The facts help us understand the issues. The facts are more likely than not some of the most important things you're going to summarize for us, because the facts often dictate whether or not the case is helpful or hurtful to our circumstance, especially if they're very close to our own facts in the case in which we are researching to help support or define a position in the law. Be sure to include the issues in the case because the court decides, and we need to clearly understand how and why the court decided those issues. And be complete in your recitation, again in your own words, of what the court did decide and why, and include how those decisions impacted that particular case, those parties, those issues, those facts. What happened? Was it reversed? If so, on what basis and on what issues? Was it affirmed on all issues, on one issue, or was it sent back for a new trial, etc.? And at this point, you know what I'm talking about. Now, common elements of a good case brief: the name of the case, the citation, including jurisdiction and date of the decision, or the decision was released. The procedural history: how did the reporting court get that case? Where did it come from? A trial court, a lower appellate court? Where did it come from and how did it get there? A summary of relevant facts. The issues, the findings, and then the reasoning. You'll notice the finding or the decision, I reverse. I want you to tell us about, why the opinion after you tell us what the court decided. And the last 2 points on common elements of a good case brief revolve around something I have been preaching now for halfway through the semester. And if you had me for intro in that course as well, own it. Leave no stone unturned. Don't hesitate to include cases that may apply. Of course, include all references to cases that you believe will apply, especially if helpful to our client's position. But remember to always include any case that may be detrimental to or contrary to the position or goal of our client. And remember why we do this. I don't want to be hit in the back of the head by something you didn't tell me about that may be harmful to our client by way of a decision that you just decided wasn't helpful. I want to know the good, the bad, and the ugly. And then finally, know, as in be able to recite the cases, their facts, the issues, the reasoning, and decision for any cases that you plan to offer or cite in a memorandum or a document to your supervising lawyer, know those cases so that if I were to call you into my office and ask you to sit down and discuss the research that you found, you weren't fumbling through files or fumbling through a computer to look up and read what cases applied. You knew them cold. Own it. And if you do own it, and if you do these things, all the things I just discussed, you will be successful. If you think about it as we wrap up week 7 and we head towards week 8, if you've been doing these things, you are far more competent than you were in week 1. You are far more comfortable than you were in week 1. And you're well on your way to taking the things that you have slowly been building on for the past 7 weeks and turning those things into knowledge and skills you can carry on throughout your career. Honing, sharpening, practicing those things forever, because as I've shared, since I first started to learn legal research probably prior to law school, so in the mid-1980s, and definitely since becoming a lawyer in 1990, they are skills that I must keep up and work on. And there are things that I definitely hope you continue to build on and work on. This is my week 7 and 8 podcast for legal research. I appreciate your efforts. As I've told you in the first week, this is the most difficult class in this curriculum. It's the rubber meets the road class. So I truly appreciate when you make it to this point and you've shown that growth. And finally, if you need me, you know where to find me.